Hey, I'm Rachel Kugel. I'm the owner and founder of the Kugel Law Firm, where we focus on DWI defense. We don't judge you, we don't lecture you, we defend you. And I'm here today answering some frequently asked questions that I get about New Jersey DWI defense. So let's jump right in. Can my New Jersey DWI or DUI charge be plea bargained to a reckless driving? Well, the answer is plea bargains are not allowed in New Jersey. It doesn't mean that cases are never reduced. It does happen. And, for people and law firms like mine who focus on DWI, and there are many of us in New Jersey who do great work and who really focus on these cases, we do get results like that with frequency, but they can't be the result of a plea bargain. Prosecutors in New Jersey are limited on DWIs to what they're allowed to offer, what pleas they're allowed to offer, and how they can plea bargain DWI cases. They're not supposed to just offer you a lesser charge of reckless or careless driving or some other ticket just because they might like you or like me or feel bad for you. They're not supposed to do it. And just like you're going into this, worried about your job, the prosecutor too is worried about their job, right? They get watched on these things. So they need to be concerned that they abide by the plea bargaining guidelines. So gone are the days where with a wink and a smile, because, lawyers play golf with each other, you get a great deal. It doesn't happen anymore, but it doesn't mean it doesn't happen. It just means that we need to actually demonstrate to the prosecutor why their case has limitations, why their case cannot be proven beyond a reasonable doubt. And if the prosecutor believes that they really are going to have proof problems in their case, then they would be, duty bound to change, to make a different outcome in the case in the interest of justice, right? A prosecutor is not supposed to try and pursue a case that they feel they can't prove beyond a reasonable doubt. And they do have discretion to make those decisions. But they need to really feel they have proof problems. And that's why it's so important to get an attorney on your side who really understands DWI law and the defenses, stays up on this stuff and the changing law in New Jersey. And as I said, there are many of us who really concentrate our practice on DWI, who will go that extra mile and look deeper into the case and know what to point out to the prosecutor, to point out those weaknesses that might just be enough to convince them that they're going to have real problems proving their case beyond a reasonable doubt. So the short answer is it does happen. Cases in New Jersey can become a reckless or a careless driving instead of a DWI, but it can't happen just as a result of a plea bargain. It has to happen because the state really and truly has difficulty proving their case. And our role in that for you is helping them see that and putting our best foot forward and our best arguments forward to point out to the state exactly why they're going to have problems taking their case to trial and proving it beyond a reasonable doubt. So holding the state to their standard is a big part of the defense attorney's job in your case. You should definitely speak to an attorney about what you're facing, what the evidence is against you, and what the likelihood is that perhaps you can find that needle in a haystack issue that's going to convince the prosecutor that they've got issues in their case and that perhaps they can't prove their case beyond a reasonable doubt, and get you the best possible outcome, whatever that might be in your specific case.